Food sits at the center of hospitality experience, comforting, nourishing, and connecting people from all walks of life. But when the food served causes illness, who is responsible? In this short documentary, we'll explore how legal concept of liability for foodborne illness has evolved over time, from being simple negligence to modern theories like breach of warranty and strict liability. We'll also examine how these laws impact restaurants, hotels, and food service providers in today's complex hospitality landscape. For much of legal history, claims of foodborne illness were handled under the doctrine of negligence. This meant that an injured party had to prove the food provider failed to meet a basic duty of care, whether by improper food handling, contamination, or unsafe storage. Unfortunately, this was difficult for customers to prove. The burden of evidence rested entirely on the plaintiff, who usually had no way to identify the specific cause of contamination or demonstrate how the provider had been careless. As a result, many legitimate claims went unresolved. Consumer rights advocacy led to a transformation in how courts handled food-related illness. Legal scholars and judges recognized that food businesses were in the best position to control safety. The doctrine of implied warranty was introduced. Under this theory, when a business sells food, it's making an unspoken promise that the food is safe and fit to eat. If that promise is broken, say a customer gets salmonella from uncooked chicken, the customer can sue for breach of warranty, even without proving negligence. Two cases helped define this evolving standard. The first one is Donoghue versus Stevenson in 1932 established the manufacturers owe a duty of care to the end users even when the user is not the direct buyer. The plaintiff who found a snail in her ginger beer set the groundwork for modern food safety. Later, in United States versus Park in 1975, a corporate executive was held criminally responsible for unsanitary conditions that led to contaminated food despite not being directly involved. These landmark cases reinforce the idea that businesses must ensure food safety throughout the entire supply chain. Today, liability for foodborne illness can be based on negligence, breach of warranty, and even strict liability. In some cases, it doesn't matter if the business intended harm or even knew of the contamination. If the product is unsafe and a person is harmed, the business may be held responsible. Federal and state regulations from the FDA and USDA now guide food safety standards, while businesses implement food safety plans like HACCP to prevent contamination. These layers of legal and operational protections define modern hospitality practices. Some hospitality professionals worry these laws increase their risk and liability, but many, including myself, see them as safeguards. Clear legal standards promotes accountability, reduce public health risk, and protect both consumers and business in the long run. Ultimately, strong food safety laws reinforce trust one plate at a time.